Good time of day, everyone, and welcome to session 4 of this inaugural annual arbitration conference of the Ukrainian Arbitration Association. And this session is going to look at the fascinating question of the use of illegally obtained documents and materials as evidence in arbitration. Great. I can see all of our great speakers. The question that we're going to consider today is not a straightforward one. It definitely has at least 50 shades of gray in terms of possible approaches and answers to it. And today we're going to be guided by 4 excellent expert lawyers who will share their views and insights on this question. And they are, first of all, Markian Malski is a partner and co-head of international arbitration, litigation arbitration practice at Arzinger Law Firm. He's the author of 4 books, more than 100 scientific papers, and more than 300 articles and commentaries. Clearly, he is perfectly qualified for this. The next speaker is Irina Chimchushin, who's an English solicitor advocate and an established international arbitration specialist. In February 2019, Irina set up Chimchushin Arbitration, focusing on her career as a full-time international arbitrator. Irina Timshin is a polyglot. She is fluent in English, Ukrainian, Russian, has working knowledge of German, and speaks French and Polish. The next speaker is Kawar Qureshi QC, who specializes in commercial litigation, arbitration, and international law. He has undertaken arbitrations and litigation for and against commercial and state parties from more than 70 states. He is the only advocate ever to have acted both for India and Pakistan in high-profile disputes between the 2 states in the International Court of Justice. And last but by no means least, we have Laurence Ponti, who's counsel at Archipel, a boutique international law firm with offices in Geneva and Paris. And prior to joining Archipel, Laurence practiced international arbitration at La Live in Geneva and worked as counsel at the LCIA, where she administered over 150 arbitration proceedings with particular focus on Ukrainian, Russian, and CIS-related matters. And I am Artem Dudko, a partner at Osborne Clarke in London. Now that everyone is introduced, let's dive into our discussion. And to begin with, I would like to set out the legal position on the issue of illegally obtained materials and its interaction with the practicalities. And I invite Kawar to start our discussion. Kawar, over to you.
Artem, hello. I hope you can hear me.
Yes, I can. Perfectly well.
Firstly, it's a pleasure for me to join you all on this discussion of an increasingly important topic. And I'll start by making some overview comments. We've got a conflict between 2 principles: vindicating the truth and preventing crime, protecting privacy. What I propose to do is to give you an outline of the approach of the English courts and the situation in England. Where in England, the situation is capable of being explained very simply. Apart from evidence obtained by torture, and the leading authority on that case is a very recent decision of the Supreme Court called Belhaj versus Straw, evidence is admissible. And there's a secondary question, namely, what happens in terms of evidence that's been obtained where the evidences have been obtained improperly? Well, there may be subsequent consequences, but that doesn't affect the admissibility of the evidence. Evidence may have been obtained by the commission of a crime, might have been obtained by committing burglary, by violating the Data Protection Act, by computer misuse. It may have been obtained by tort, trespass, conversion, breach of contract, breach of confidence, by violation of the right to privacy contained in Article 8 of the European Convention on Human Rights. All of those are factors that the court will take into account in determining the weight of evidence, an English court, and not admissibility. One of the most important cases that confirmed this was a decision of the Court of Appeal in a case called Jones versus the University of Warwick, where clandestine recording of an individual who'd made a personal injury claim, including getting into his house without permission, was admitted to determine whether or not the personal injury claim was proper. But there was a sanction that was applied by the court for this covert action, namely costs. Throughout the proceedings, the costs that had been incurred by the victor were disallowed and the costs of the other side were allowed. Another consequence of the attempt to use evidence that's been obtained illegally so far as courts are concerned, a decision of our court of 1999 of Mr. Justice Ricks in a case called Dubai Aluminium versus Al Alawi sets out very clearly that if we as legal advisors are deploying evidence before our courts that has been obtained through criminal processes, that means access by virtue of burglary, Data Protection Act violation, the court can and will pierce legal professional privilege and order production of these documents. So that's a court, and that's the English court position. Pretty clear, admissible. The issue that then turns on weight, relevance, and what sanctions, if any, the court will apply. That depends on the gravity of the breach. Arbitration. But the arbitration institutional rules are pretty silent. You've got a duty to act in good faith on the part of the parties, and you've got fairness, equal treatment, equality of arms. Is there a legal impediment? Well, the IBA rules on the taking of evidence, which have just been revised as of 17th of December 2020, at Article 9.2, require the tribunal not to admit evidence if there is a legal impediment. What does the legal impediment arise from? Possibly the applicable law of the jurisdiction where the arbitration is seated, maybe even the applicable law where the evidence was obtained. Very recently, 17th of December 2020, the modification that's taken place to Article 9, and it's come into effect on the 15th of February of this year, it's an important modification, Article 9.3. Now, an arbitral tribunal may, of its own volition, or if asked by the parties, exclude evidence obtained illegally. The commentary, which you should look at to the IBA rules, explains that the provision is permissive, it's not mandatory, largely because of the differences in approach in different jurisdictions. I mentioned the approach in our courts. In America, because of the US constitutional framework, there's something called the exclusionary principle, and that also applies in some civil law jurisdictions, thanks to constitutional law. Now, very briefly, I've mentioned 3 cases where the question of illegally obtained evidence has been considered. Firstly, the International Court of Justice, which I've had the honour to appear before, in a case called the Corfu Channel case, the UK against Albania. UK argued that Albania was illegally, improperly preventing free access through its territorial waters. To prove its point, the UK collected mines from Albania's territorial waters. Now, what the ICJ held was, by going into the territorial waters to collect mines, the UK behaved in a manner that violated Albania's sovereignty. However, the evidence wasn't rendered inadmissible. It was deployed and had regard to by the court to determine that Albania had acted unlawfully. 2 other decisions, Methanex versus the USA. This was a NAFTA claim brought by a Canadian party. Its product, which was a fuel additive, had been banned in California. A decision of the NAFTA tribunal in 2005 excluded evidence that had been obtained initially, Methanex said, by trawling through bins, which are in a public space. And then Methanex said, well, actually, maybe the bins were in a private space, but the door was open. And the arbitral tribunal concluded that none of that evidence was admissible, not least because of the INSITRAL rules requirement for parties to act in good faith and for the parties to be treated equally. The tribunal also held that their evidence in any event was of marginal significance. Very recently, more recently, there were secret recordings that took place, contrary to Romanian law, in the context of a claim that had been brought by Romania by EDF. And in a procedural order, number 3 of 28th of August 2008, the arbitral tribunal excluded the evidence that Romania had obtained, covertly recording one of the claimant's associates, on the basis that this was a violation of procedural fairness and the duty of good faith. So ultimately, now that we've got this new rule change, what does it do? It enables the arbitral tribunals to weigh questions of proportionality much more carefully. We can see a big difference in terms of English court approach, the International Court of Justice approach, and the few arbitral tribunal decisions that we've seen. If the evidence is already in the public domain and it cannot be attributed to the party that's seeking to deploy it, well, it's unlikely to be excluded, and there's unlikely to be any sanction. I'll stop there to invite any questions and discussion. Thank you, Artem.
Thanks, Kawar. Clearly, there is, as expected, a whole variety of approaches from different courts. And then let's just hear from some of our other speakers on some of their experience that they've seen in the differences in approach. Irina, turning to you for a short comment on the differences in approach by courts to this issue. What would you like to say?
Well, I think that obviously, as just a very good summary was given by Kava, is that the English court takes a clearly open view on that. And in my experience, both as counsel previously as also as an arbitrator, I have to say that usually it is very open question that evidence is admitted. We always can, any evidence goes, and initially, I was quite surprised that this may be the case, but reality is the pursuit of the truth seems to be more important. I will address later in relation to enforcement another case which Hava didn't mention, which is Sinaco International and RBRG, which is the most recent Court of Appeal case, which sets up very useful principles in relation to the illegal evidence. But obviously, I'll leave it for later.
Thanks, Irina. And Lawrence, what is the approach in Switzerland?
Thank you, Artem. So from a Swiss perspective, what I think is interesting to mention is that before 2011, so about 10 years ago, so before the harmonization at the federal level of both the civil and criminal proceedings rules, the rule established by the Swiss Supreme Court was basically that illegally obtained evidence was never admissible. But the position has significantly changed since then, including in light of the case law over the last 5 years. And it now seems quite clear that the test to decide on the admissibility of unlawful evidence is now unified. It is a balance of interest test, although there are a few nuances depending on the nature of the matter. So, in civil law matters, for example, in practice, the same tests will be applied to determine whether whether evidence is both legal and admissible, namely whether there is an overriding interest in finding the truth versus the personality rights potentially infringed. In criminal law matters, the Swiss Criminal Procedure Code provides that illegally obtained evidence, such as, for example, evidence obtained or based on systematic surveillance conducted by private detectives, is inadmissible unless it is essential to secure a conviction for a serious offense. And I would say that, as a matter of administrative cases, the approach is more or less the same and was actually underlined by the case law, by a decision of the European Court of Human Rights rendered in 2016, which I think is a very interesting case. Now, in Switzerland, in the context of arbitrations seated in Switzerland, all those rules are not bound on the arbitrators, but nonetheless, Swiss law may directly or indirectly impact on the decision making by the arbitrators.
Great. Thanks, Lawrence, for that. And Markian, turning to the host jurisdiction for today's conference, Ukraine. What's the situation? What's the situation there?
Thank you, Artem. Thank you, dear colleagues. Great to see you all here with our participants joining us. I will say that this topic is still very much developing in Ukraine. I wouldn't say that this is already, an answer, a question well answered. If we look on the case law, if we look on both criminal and civil matters, then I would say in criminal this is much more of a subject which is such a groundbreaking thing, because from criminal cases we see that very often the admissibility and legality of evidence may break the whole case. And that is what we've often seen in a number of cases. In the civil law matters, I would say that judges or arbitrators will probably take into account the evidence, and then, as already mentioned, will be an approach of truth somehow prevailing over the admissibility of a certain part of evidence. But I would say that the arbitrators or the judges in those cases would most certainly substantiate their reasoning with other evidence. So I would draw a line here that in criminal matters, the judges would much more strictly look into the admissibility of certain illegal evidence, and this is often the case where the lawyers try to bring up this matter. And then if the judges find it inadmissible, then basically I would say it could ruin a case of the prosecution, for example. And that is very often the strategy of attorneys in criminal cases. In civil, as I already answered, I would also point that the representatives of a party, of course, if they see an inadmissible evidence, for any lawyer, I think this is a red flag to start acting. And you would, of course, bring this up immediately and say, well, look, this is inadmissible because A, B, C. And then this would, of course, be a very big subject for debate before the decision-making body. But as I'm telling you, this is still a very much terra incognita in many issues. And I believe only based on case law we can see some examples, but there are no general rules yet. And of course, we will be discussing this during the day of today.
Thanks, Mark-Jan. It seems to be that although there are different approaches from different jurisdictions, there is still an element of trying to accommodate evidence, but depending on the severity of how it was obtained is playing an important role. And I think that's the next question that we're going to turn to, is of all the different kind of possibilities of levels of impropriety and how the courts deal with that. So, Laurence, can I turn to you to introduce this next theme to us, after which I'll go to Kawar for some quick comments before he has to unfortunately depart our session. So, Laurence, over to you first, please.
Sure, thank you very much, Artyom. So I think I will start with a practical example, and that's that of an arbitration case seated in Switzerland and governed by Swiss law, in which my firm was involved a few years ago. In that case, the claimant produced and relied on recordings of phone calls or live discussions, including in London clubs, between representatives of both sides, which had been made over several years without the respondent's consent at the time. And the respondent argued in particular that the recordings were illegally obtained in view of the Swiss criminal code. And the claimant in reply first argued that because the recordings were not made in the territory of Switzerland, Swiss law had actually no bearing on the legality of the recordings. And it further argued that in any event, as a matter of Swiss law, arbitral tribunals have broad discretion to accept evidence, whether legal or illegal. And it relied in particular on the Swiss Code of Civil Procedure and also on the case law of the Swiss Federal Court, which found in the context of a sport arbitration case that the arbitral tribunal could admit illegally obtained evidence where the interest in discovering the truth outweighed, I quote, the legal interest harmed by the acquisition of the evidence. As a matter of legality, the respondent replied that it is still an offense under Swiss law to use such recordings, even if it was not an offense to make them in the country they were made. And as a matter of admissibility, the respondent replied that unlike in the sports arbitration case relied upon by the claimant's interest was not worthy of any protection, as it was simply private business interests, and that there was no reason why this private interest should prevail over the right to privacy of the respondent and its employees. Whereas the sport arbitration case related to disciplinary proceedings and quasi-criminal behavior by the party seeking to prevent disclosure. So what was the arbitral tribunal's decision? So first, by way of a procedural order, the arbitral tribunal ruled that the recordings should be kept on file, but that these did not prejudge the evidentiary weight which the tribunal would give to the recordings. And the tribunal acknowledged in particular the fact that the recordings were made by the claimant without knowledge, let alone the consent of the other party to the conversation. And it indicated that it would bear this in mind when assessing the evidentiary weight of the recordings. Then, at a second stage in the final award, the tribunal decided that given that both parties had extensively relied on the recordings in the course of the proceedings, it would rely on them only to the extent that they corroborated findings at which the tribunal arrived on the basis of other evidence on the record. And this leads me to make three remarks. First, that the tribunal was not primarily concerned by the fact that the recordings would have been illegally obtained as a matter of Swiss law, but rather that they had been made without the consent of the other side. So the tribunal was concerned by the fact that the recordings had been obtained in a disloyal or unfair manner rather than in an illegal manner. And as we have just heard, national laws and courts treat the making of audio and video recordings and other practices such as the leak of documents to the public domain in different ways. And I'm thinking in particular of two decisions rendered in the context of arbitral proceedings by the Israeli and Italian courts respectively, involving the Economic Intelligence Agency Black Cube, in which both courts found that the use of false identities and the making of secret recording by the Black Cube agents was not illegal. And there is certainly an increasing number of situations where arbitrators are confronted with the issue of admissibility of evidence that is neither manifestly unlawful nor inadmissible, but that raises some questions of fairness regarding the taking of evidence. And as we've heard as well, since the principle of fairness is precisely a cornerstone of the arbitral procedure, it seems to be the proper angle, or at least one of the angles from which arbitral tribunal should deal with the issue. And this is what was made, for example, by the tribunals in the Metanex case, which was referred to, and in the Libanenko case as well. But at the same time, a party which is weaker than the other, or when it comes to establishing serious facts or offenses such as corruption, the use of tactics in obtaining evidence may appear legitimate or more legitimate. And this is why fairness should probably be envisaged from a global point of view. And the best way, as I see it, to achieve this is perhaps to apply a balance of interests approach. It's probably the best way to grasp the whole spectrum of seriousness of illegality / unfairness in obtaining evidence, and how this should affect the use and admissibility of evidence. And this
Laurence,
leads,
if I can just,
yeah,
sorry, if I can just pause you there. I know Kawar has a strict stop time that he needs to do, so I'll just
sure.
turn to you, Kawar, for any quick comments before you leave us. Anything to add on this point?
Yes, thank you, Lawrence. That's very helpful. And my apologies for having to depart. It's a fascinating discussion. Ultimately, the balance, it's reflected. We have a statute called the Police and Criminal Justice Act of 1984, Section 78. It's about probative value versus prejudicial effect. So there are essentially three elements. Firstly, how relevant is the evidence? Is it consistent with other primary evidence, supportive of primary evidence? Second, how was it obtained? The greater the turpitude, i.e. the more serious the violation of criminal law or right of privacy, the more difficult it is for a court and or tribunal to admit it, in the sense of to allow it to have influence on the decision. And then ultimately, the question is, once we've admitted it, if we've determined that it's relevant, what other sanctions can be applied? And we've seen that consistently what happens in the English courts is that once it's admitted, if it's deployed, if it's successfully deployed, then the sanction that the court can apply is censure by way of costs. So, Artem, if I can be forgiven on that point, thank you very much. My apologies again for leaving so abruptly, but best wishes for the remainder of the conference. I
Of course, Kawar, and thank you,
which can be circulated.
Thank you very much. Yes.
Thank you. Take care, everybody. Bye-bye.
Take care. Bye-bye. And Lawrence, apologies for interrupting you, but please continue. But I think I made some helpful additional comments to that.
Of course, no. Thanks a lot, and I'll try to be short. But just to bounce back on what said, I think that in making this balance of interest exercise, arbitral tribunals, although they are not necessarily bound again by national laws, should not hesitate as a matter of guidance to look at the criteria established by national laws, national courts, and also international courts. And I have already mentioned what are the criteria taken into account by Swiss statutory and case law. And again, if these criteria do not apply directly, they still constitute helpful guidance in my view. I also mentioned a 2016 decision of the European Court of Human Rights rendered against Switzerland, which I find useful in that for the courts, the issues to be examined were first whether the applicant was given an opportunity to challenge the authenticity of the evidence and to oppose its use. Second, the quality of the evidence. Third, the circumstances in which it was obtained and whether these circumstances cast doubts on its reliability or accuracy. And finally, whether the evidence in question was or was not decisive for the outcome of the proceedings. So it more or less overlap with the criteria we've heard. Last one point, I would like to emphasize on the significant role played by the CAS, so the Court of Arbitration for Sports case law, in providing guidance in this respect. And I feel that I ought to do so since the CAS is based in Switzerland. And I would like, for example, to mention the Fusi Malohi versus FIFA case in which the tribunal conducted a thorough balance of interest exercise and took into account, for example, the nature of the infringement, the interest in getting at the truth, the evidentiary difficulties for the interested party, the behavior of the victim, etc., before deciding that the interest in keeping recordings confidential was outweighed by the interest of FIFA to use those for disciplinary purposes. And a similar approach was also taken in subsequent CAS decisions concerning match fixing. Now, while the interests of discovering the truth are usually strong in the context of sport disputes, they do not necessarily prevail in all cases, and that is particularly so with respect to coerced evidence. And with this, I'm done with my remarks, and thank you very much for your attention.
Thanks, Laurence. It's really, really fascinating. Markian, turning to you for some brief comments before going to Irina. What I'd like you two to comment on this stage is it clearly seems to be that the approach generally is one about balancing the different interests. However, that approach, although theoretically gets to the right result in terms of fairness, is very unpredictable. And would it be better if there is a much more black and white, clear-cut approach, which is less fact-specific? What do you think, Markian?
Thank you, Artem. The first counter question appeared to me was, now, how does that make you feel? And I think that basically, this is very subjective. And I mean, how does this make an arbitrator feel if he sees a certain part of evidence being illegally obtained? And I think the spectrum is broad of how does this make us feel. So this is, of course, very subjective. And I think what you say by whether we would need something being written and accepted as black and white, I think here is much more complicated. So as the spectrum of seriousness, as we've formulated this in our discussion of illegality or impropriety, is very much different and depends on case-to-case basis. I think this will be very complicated for the lawyers to sit down and firstly formulate and then secondly agree upon this. So I do believe that this will remain an open question for many years still. And of course, we lawyers like black and white things. But I think this world is much more colorful, and I believe that in different cases this may be very, very much different. So I don't think we need something very strict. We may have something soft on those matters, but I think this is exactly for the case law to formulate, and then the other arbitrators feeling, in a way, the case will be able to choose from the existing case law how to judge upon this matters. I do believe that some helpful guidance would be, of course, good. So I'm pro discussing such matters, of course, on conferences and so on. So we can say that already some criteria from different case law exists, but I would definitely leave this to a broader discretion of the arbitrators, how in a definite case they would see this situation themselves. Thank you.
Thanks, Markian. I actually think that we as lawyers prefer it when it's much more colorful, as it gives us much more opportunity to practice our craft. If it was all very obvious and black and white, there would be very little for us to do. Irina, as a experienced arbitrator, what do you think on this kind of the range of approaches and this balancing exercise?
Well, in the last year, I sat in two cases, in one as a co-arbitrator and the other as a sole arbitrator, where I had to face the issue of illegally obtained evidence, more particularly forged evidence, which was clearly forged, but that did not make the issue any easier, because when you totally understand what you have facing, and the most important issue is how to make sure that you make the right decision, so the ultimate award in this case will be enforceable and not challenged on the basis that evidence is improperly admitted, not admitted, and so on. So how do you face these issues? And in that context, I have to say that I think I actually do welcome introduction of the revised IBA rules on taking evidence, because that's actually the first I think, codification, if you wish, of the existence of illegally obtained evidence and what the tribunal is meant to do with that. And I think the fact that it actually specifically provides for excluding evidence obtained illegally actually implies that prima facie illegally obtained evidence is admissible unless established otherwise. Okay, we probably have known it for a while, but it actually, for an arbitrator, it makes it much easier morally, and that you are doing the right thing when you actually know that you have to decide if there is any good reason why that evidence shall not be admitted. And of course, it also greatly depends on the seat and depends on the applicable arbitration rules. In that regard, I would say Singapore arbitration rules probably slightly ahead of the curve, because they do exclude interference of the applicable law or application of applicable law to the issue of admission of evidence, in which case it actually cuts the submissions half, especially if you speak about parties from the Eastern Europe who are particularly keen on making submissions in that regard. But with that, I would, if you don't mind, I would like to move to the issue of enforcement.
Yes, of course. Of course. No,
ready.
well, I think we're ready, and it's very important, because when arbitrators have to consider these issues, it's really important that they don't only consider the issues of the currently applicable laws to their procedure, to depending on where they're seated, what is the applicable substantive law, but also to consider what possible jurisdictions the ultimate award will be enforced in, and what would be the approach of those jurisdictions on these issues with a view to potential challenges. And Irina, back to you to kind of set the scene for that next theme for us.
Yes, thank you. Well, first of all, I will start with possibly basics, but I think it's important to mention that obviously topic of enforcement, we all have to remember that the enforcement of arbitral awards is one of the key attractions of international arbitrations. It's a selling point which most clients and parties actually agree to arbitrate on, because they understand that gives them that extra advantage of enforcing the award in 159 jurisdictions, as if I remember rightly. So, and also, obviously, New York Convention, which governs enforcement, is drafted in such a way that the grounds for refusal to enforce an arbitral award are limited to a rather narrow list of irregularities. So, and these irregularities are set out in Article 5 of the New York Convention, and most of them are focused on arbitral procedure, which I don't propose to address in great detail at this point. But the most commonly invoked, and I'm saying most practitioners will agree with me here, is Article 5(2)(b), which provides that the court may refuse enforcement if it would be contrary to the public policy of that country. And I think in the last 5 years, I probably can count on one hand arbitrations where that argument was not brought still in the actual pleadings as a slightly covert threat to the arbitrators. What happens to you if you don't do the right thing? Sort of just kind of taste of things to come. Yes, so how to deal with that? Obviously, the public policy exception is the most vague ground due to its constantly evolving nature and multi-jurisdictional nature, and because it's interpreted differently in different jurisdictions. Hence, it's obviously the first choice for the parties to challenge an award, because you can basically throw a kitchen sink into that and hope it swims. So, and obviously where it concerns illegally obtained evidence, that's a most likely ground which would show. So now, most arbitral rules provide that, as we heard already here very helpfully from previous speakers, that the power to determine the admissibility, relevance, materiality, and weight of the evidence is on the arbitral tribunal. So obviously that shifts the burden, and as an arbitrator, that's where you have to think carefully how to make sure that you comply with the due process and yet obviously do the right thing, but the decision is well balanced, and you achieve that you perform that balancing exercise to perfection, to the extent that is possible. And again, as I said, I think appearances of things like Article 9.3 is very helpful. 9.3, of course, of the revised IBA rules, because there had to be at some stage some saying that allowed illegally obtained evidence exists. And I think I probably would like to see them further illegally obtained as opposed to unlawfully obtained or unethically obtained, because obviously what is illegal, strictly speaking, and what is the old good English argument, I was walking on the street and I found an envelope, I opened, wow, it's bank accounts, which are so handy for my prison injunction. So, it's not illegal really, it's just you found it on the street and that's the way it is. And we all know that. But the point is, it would be helpful if we had that clarification further, because it would make life easier. But I personally found very helpful even the commentary of the IBA 2020 Review Task Force, where they use an example of a recorded conversation in a country where recording conversations are prohibited as something which could be admissible. And that already gives a certain indication what is acceptable. And certainly it resonates with what Laurent said earlier, that there are certain acts which parties already can predict. But I think it's very important to draw a line and be very careful that parties are not encouraged to perform this act knowing that it probably will be admissible. And we all know from the practice as counsel that you have always a client who will say, oh, what evidence do we need to win this case? Ominously suggesting that just tell me what's required, you will have it tomorrow. So, or whenever. But it's obviously very dangerous grounds, because that can be interpreted as invitation to, illegally obtain evidence or manufacture some if there isn't any. So how do the actually courts, and we today heard some instances, treat challenges of arbitral awards on public policy grounds? I mean, obviously we all had threats in the pleadings in actual arbitration, and thankfully it never reached courts, at least in my case for sure for now. But how the courts treat it, and here I would actually bring two examples. And one of them actually from Switzerland, and I believe Laurence may have mentioned it generally, but I thought I may mention it because it has connection with Ukraine. So I thought it actually would add the local, and you, Laurence, you probably know what I'm talking about. It's a case between the Swiss Federal Supreme Court in 2014, which related to the Courts of Arbitration for Sport decision in a match-fixing case between two Ukrainian football clubs. So, and that was Karpat Lviv and Metalist Kharkiv. So, and that was quite, I will not go into merits of that case, but bottom line is the party who lost on that particular one, which happened to be Metalist, actually appealed to the court, and the appeal was based on the argument that the procedural public policy was violated by relying on illegally obtained evidence. And that's where, as Laurence already helpfully mentioned, that Swiss Supreme Court held that illegally obtained evidence is not inadmissible. So, which in all cases, and the balancing exercise between the truth, discovering the truth, and the interest of preserving the privacy of the parties have to be conducted. And in that particular case, given the gravity of the offense and the public interest in the fight against match fixing, it was obviously rejected. So that's one case which definitely resonates with this topic. Second one, which I mentioned at the outset, is Synaco International and RG, UK Trading. So that's a Court of Appeal case, and a case which went a long way. Basically, again, without, in the interest of time, just in a very brief summary, it's a case of Chinese
Yes, we need
company.
to move on.
Yep, okay.
So
basically,
if you can, yeah,
very
go on,
complex
just go on,
case,
Irina.
but basically the award was appealed all the way to Court of Appeal. And here I would just like to say that Court of Appeal in that case provided very useful precedent, which I believe for the arbitrators would be extremely useful guidance. And I'll just summarize these four principles in conclusion. So first, if when public policy is relied upon to preclude enforcement, it should be given a restrictive interpretation and approach with extreme caution. Second, when the arbitral tribunal has jurisdiction to determine the relevant issue of illegality and has held there is no illegality, the English court should not reopen the facts apart from exceptional circumstances. Third one, where on the facts it is found that there is no illegality under the governing law, but is under English law, public policy will only be engaged when the illegality reflects consideration of international public policy rather than just English policy. And finally, in considering when public policy is engaged, the degree of connection between the award sought to be enforced and the relevant illegality will be important. So, and in absolute final summary, so the court actually went to indicate that any public policy considerations are clearly outweighed by the interest of finality, which is very pro-arbitration approach. And I think it's very positive outcome for the arbitration practitioners and for arbitration community. And it's a very useful precedent, which we shall use. With that, I will conclude.
Irina, with very limited time, but thank you very much. I mean, I'm sure all of us could carry on talking about these issues for a very long time, but we need to move on. Laurence, on this issue of enforcement, do you think arbitrators should be considering these issues when writing their awards in terms of will this be challenged at the enforcement change, or should they be more concerned with getting the award right in the jurisdiction where they're writing it?
Well, I think, yes, they should keep this in mind. But as Irina explained, at least from a Swiss point of view, arbitrators are in principle, well, they enjoy extensive freedom in this respect. They're indeed limited by, equal treatment of the parties, right of the parties to be heard, and public policy, procedural public policy. But procedural public policy is regarded in a very liberal manner by Swiss courts and by the Swiss Supreme Court in particular. And again, as also explained by Irina, the case law in arbitration, in sport arbitration, helps define exactly what means procedural public policy in this context. And I will just quote that, illegal evidence does not automatically concern Swiss public policy, which is violated only in the presence of an intolerable contradiction with the sentiment of justice, to the effect that the decision appears incompatible with the values recognized in a state governed by the rule of law. So again, it shows that where the balance of interest test is carefully conducted, there is very little chance that the use of illegally obtained evidence in arbitration proceedings and the award rendered at the outcome will violate public policy, at least Swiss public policy.
Yeah, thanks, Laurence. That's a very liberal approach, as you say, on that issue. Markian, I'm going to turn to you for the final theme for our discussion, and that is that when issues of illegally obtained materials or documents come up, it potentially triggers a whole range of issues for the different participants in the arbitration, and these would be either counsel or arbitrators, in the sense that some of these individuals have various regulating authorities. There are various obligations that apply on them. And can I ask you to talk to us about this topic and how these kind of considerations affect what actually happens with illegally obtained materials when they arise?
Sure. Now, that is a very, very interesting question, and it all leads to many issues, as you say. So the first would be, is there a duty of an arbitrator or a counsel to notify, for example, law enforcement bodies about the illegality of all evidence procurement? And now, in this regard, the duty, if we are speaking about the Ukrainian law, is still very much silent. And I would say that we had an interesting situation that when still a Soviet criminal code existed, then there was a general obligation to notify of all known crimes, and basically you would have to report on anything. And now the law has changed, and the criminal law is now much more liberal towards those who know about certain crime, and basically they have no duty to report. This is the general approach, and basically unless they do actively something in order to prevent the investigation or to prevent the leakage of information that some crime has taken place, there's very little chance that they will be criminally liable. So there's a very interesting change in the mindset if we take the Soviet and the more liberal and common approach. But if we speak about the illegality of means to procure evidence that is being presented in an arbitral proceeding seated in Ukraine, then we would analyze 4 issues. The first one being the general statutory requirements, including criminal law statutes, then the rules of arbitral institution, and then ethical rules. And those are the main issues to analyze. As I said, in the Lex Arbitri, in the International Commercial Arbitration Law, there are no provisions establishing the express duty of an arbitrator or counsel to notify in such cases. If we're speaking about the general duty, as I mentioned, there is a change in the criminal codes. The current criminal code nowadays says that there may be a liability for failure to report on another person's crime if, for example, the official in certain cases is liable if this official has not reported a crime committed by subordinates or persons under his control. Such acts are qualified as crimes in the sphere of official activity. And then second, knowingly giving false testimonies. This is rather clear, and this may involve providing testimony with the intent to conceal information about the crime of another person. And then third is the refusal to testify, which covers acts committed to the purpose of not reporting a crime committed by another person. And thus, generally, a person has no statutory duty to report about crimes of others. The person must make such a notification only when he or she has a special duty to do so. So this duty must arise based on the law, official position, procedural status, such as witness, translator, or expert, but not otherwise. And then similar concepts apply to those types of illegality that do not raise to the level of a crime, and Ukrainian legislation does not impose any duties to inform about mere procedural violations. If we speak about duties established by institutional rules, most of the rules, LCAA, SCC, Ukrainian rules, contain no express provisions on the duty of a counsel arbitrator to notify law enforcement in such case. The most popular institutional rules in Ukraine also do not impose such duties. The LCAA rules do provide the possibility of arbitral sanctions against counsel for ethical violations, not only in the form of cautions and reprimands, but also in the form of a reference to the legal representative's regulatory and/or professional body. But it would have to be egregious conduct indeed that would induce arbitrators to be sufficiently concerned or sufficiently officious to invoke the law enforcement mechanism. The desire to maintain the privacy and confidentiality of the arbitration process will, I think, further militate against disclosure of anything like this. If we are speaking about the ethical rules, those are still very much soft in Ukraine, and they also do not put such a burden, and it's very much a discretion of the arbitrator or the counsel in terms of how to react in such a situation. Of course, there's always a right. There's always a right to report. However, I think this is not often the case. If we even though there's no duty, no express duty, I think it is up to everyone to think how to act. And I will just end my brief presentation here with a very interesting case when two counsel have understood during the hearing that both clients to them have forged documents in the proceedings. And it was very interesting to observe when both counsel understood that they are both acting on forged documents in the process. And when the judge understood this as well, he asked, well, is any of the counsel going to claim an expertise regarding those documents? None of the counsel did. And then the judge did not find enough, I don't know, either will of power or legislative grounds to order an expertise himself. And he was basically deciding the case upon what he thought was legal. So this was a very interesting situation. And upon this, I will end my short presentation, and thank you for your audience.
Thanks, Mark-Jan. We're all smiling, but it's scary that these things do in fact happen in reality. For some very brief comments, both to Lawrence and Irina, on the situation in your jurisdiction on these additional obligations and regulations. Lawrence, first to you. What's the situation in Switzerland?
Well, in Switzerland, a lawyer who is aware that the evidence has been illegally obtained faces two risks. First, a criminal complaint being filed against him or her, and second, a disciplinary sanction under the law on the legal profession. And that would, in particular, be on the basis of the specific duty of diligence provided for by the law, which imposes on lawyers to defend their clients' interests by using the legal means available. And a lawyer would only be able to defend him or herself by demonstrating that the specific conditions provided for by the Swiss civil or criminal procedure codes are fulfilled. And if Swiss courts may show more flexibility in the case of private individuals, lawyers will certainly not benefit from any flexibility given their legal knowledge. Now the question arises as to whether the sanction would be the same for evidence obtained in a disloyal manner. And my guess is that the risk to face criminal or disciplinary sanction would be the same, would be similar. First, because according to Swiss case law, if the person against whom the evidence is relied upon was trapped, if it did not provide the evidence on its own initiative, the evidence should be considered as inadmissible. And second, because the specific duty of diligence is certainly broad enough to embrace this situation. And maybe just one additional word regarding economic intelligence agencies. I think that they can likewise, face a risk of criminal complaint, but because they're not regulated in jurisdiction as in Switzerland as in many other jurisdictions, I guess, they cannot in principle be subject to disciplinary proceedings and sanctions.
Thanks, Lawrence. And Irina, last final comment from you on...
Okay. As you obviously well know, in England, there are plenty of legislation which relates to data protection, money laundering, and you name it. However, before going into any of that, I would say one thing. With the illegally obtained evidence, one important thing is that it's usually an allegations which almost never accompanied by any real action on the ground or any even police complaint or any pursuit of sanctions otherwise. It's just merely allegation which is cast mostly to create literally just a bias for arbitrator or purely affect reputation rather than actually get anything tangible. So it would be imprudent and inappropriate for an arbitrator to do any act on mere allegations that somebody forge the document, especially if there is no evidence. An arbitrator shall not play a role of a police man or woman in order to investigate that. It's definitely outside arbitrator's domain to investigate any criminal allegations, because there are certain authorities for that in every jurisdiction, and the party shall not be using this approach in order to actually often derail arbitration.
Thanks, Irina. As mentioned previously, we could discuss this fascinating topic for hours, and there is plenty to discuss. Hopefully, the comments made in the last hour have made all of our participants realize some new things, some interesting thoughts, and perhaps, I don't know, Markian, as you mentioned it, there is some scope for some soft law on this particular issue to be considered by some of the arbitral institutions or organizations. But we have run out of time. And so I would like to thank all of the speakers for their very insightful and interesting comments, the Ukrainian Arbitration Association for organizing today's event, sponsors for making it possible, and most of all to the participants for listening. Thank you very much, and see you at the next UAA Arbitration Conference. Thank you. Goodbye.